And in general, there are three major tasks that reform of the statute should accomplish. And as I say, there's a certain amount of consensus on at least some of these. The first is with respect to Congress, the act should severely constrain or maybe eliminate completely Congress's ability to reject a state's votes based on Congress's disagreement with the voting process that took place in the state. When Congress meets on January 6th, it's not a national recount board. It's not a court to second guess court decisions that have been made by state and federal courts. And so this means various reforms to the act that make it much tougher for members of Congress to object. Right now, it takes only one senator and one representative to trigger an objection process for receiving the votes from a particular state. That needs to be raised to maybe 25%, 33% of Congress being needed to object before an objection becomes a valid objection that starts the debate. Maybe a supermajority requirement before any objection can actually be accepted, that is, votes from the state thrown out, and also sharply limiting the grounds on which Congress can object. And as I say, there's significant consensus in the bipartisan group of senators that we've been working with to take a number of these steps. Ned and I would probably go quite far in this direction and eliminate any role for Congress in second guessing the votes from the states based on the voting processes that took place there. But there will be movement in that direction, wherever the Congress exactly ends up. The second thing is with respect to the states, much of this is already the case, but it's not clear. So the act has to make very clear that states have to conduct their election processes and any processes for resolving disputes about the election through laws that are enacted in advance of the election. Legislatures cannot come in after the votes have been cast and decide that they now are going to appoint electors themselves. That's already forbidden in current law, but that needs to be made more clear. The act has to also clarify which institution in state government has the power to determine the lawful winner of the election. So that if we end up in a situation in which different parts of the state government attempt to send different slates of electors, the governor sends this slate, the Secretary of State certifies a different slate. The act has to make clear in advance which of these Congress is supposed to count. And finally, there's this provision that Peter referred to called the failed election provision, which goes back to 1845. I called it a loaded weapon in the system. It gives state legislatures the power to appoint electors if the election has failed. That's the term in the statute in their state. The provision was there to deal with a potential natural disaster or something like that precluded voting in the state. But it's not specified in the law currently what a failed election is. And we now face a risk that legislatures are going to claim if there's something they don't like about the voting process, if the courts are taking a long time to resolve the outcome, that the election has somehow failed. That's a very dangerous provision. And so Congress, as part of reforming the statutes that regulate the presidential election process, needs to close that loophole and make it clear the very, very limited circumstances, such as a natural disaster, in which the state legislatures might be able to appoint electors if no election is actually possible on election day. The third thing, which is the most difficult issue here in the reform process, is there needs to be an additional role for federal courts laid out in the statute, a role that's very limited, very minimal, but is there to ensure at the last stages of the process that if we face the situation of, let's say, recalcitrant governors who refuse to send to Congress the slate of electors that have been appointed in that state, a scenario we now worry about, that there's a recourse for that in the federal courts. So removing Congress from the role of second guessing the state processes, making clear that the state has to function according to law established in advance of the election, making clear which part of state government has the final lawful authority, and a backstop role or an insurance role for federal courts. In our view, those are the three key elements in reforming this statute. But as Mike said, this is an incredibly urgent task right now because we cannot go into the 2024 election with all the legal uncertainties that currently surround the basic legal framework for dealing with the presidential election at the national level.